SJC-10339, Commonwealth versus Facella.
Good morning. If it pleases the court, excuse me, my name is Brian Kelly. I represent the defendant appellant Joseph Facella in this case. Before I start in the argument, I would like to, of course, acknowledge that there was I agree with or I concede that the argument that I had regarding a misquote in the limiting instructions turned out to be an error, a scrivener's error by the.
I think we understand that you were relying upon an earlier transcript.
Yes,
so
Your Honor.
The error is not yours.
I actually never thought there was anything, but Judge Lowy was doing anything purposely that way. I figured it was a slip of the tongue. I figured it was you should versus should you, but of course the jury wouldn't have known the difference. But Attorney Semmel has done some digging and found out, so I just want to acknowledge that that is a moot point at this point. I would like to, unless the court takes me anyplace else, would like to call the court's attention to basically three areas in which, or three types of evidence in this particular case where there was prejudicial evidence shown. One was the two letters that were introduced by the defendant to the victim from prison. Two was the rebuttal testimony of Ms. Ellen Markham, a girlfriend of the defendant from 23 years prior to the incident. That's the topic of this case. And the third was the other rebuttal witness who we've given a pseudonym Beth to, which was 12 years prior to that. In arguing for the prejudice in this thing, I would urge the court to basically, I've conceded already that, of course, prior bad act testimony or other bad act testimony, as I think it's now called, is of course acceptable in rebuttal situations when, as in this case, the defense was brought up. I don't think there's any question about that. However, just because such evidence is or could be considered relevant as to try to counteract such a defense doesn't necessarily mean it's admissible. The case law has.
Can we take the letters separately from the?
Yes, Your Honor.
From the
Sure.
Prior instances of domestic violence. The letters, as I understand it, were offered to show kind of the cycle of violence, the cycle in the domestic violence. It's I love you, and then I'm gonna do bad things to you later on. And as I understand it as well, the defense attorney was offered a limited instruction regarding jail and declined, didn't want to highlight it, made a strategic choice.
As to the second part of that question, yes, I would think that's probably good strategy not to highlight that. I think we've all seen that done before.
Yeah, right. That's
As to the first part of that question, Your Honor, regarding the Commonwealth actually makes the comment that it's, I think the word is inextricably intertwined is the terminology that usually gets used in that. And I would suggest to this court that the probative value of showing the, I guess they call it in a domestic situation, a honeymoon and antagonistic or whatever the other word is. I think that the probative value of that is extremely low versus showing that these letters were written from a prison.
No, I've not looked at the letters. What is it about the letters that
It's
says?
not the fact of the letters themselves. It's the fact that the jury was informed in bringing these to the court that these were written by him from prison.
But I guess looking at it in context with the incidences of violence that were allowed in, it's hard to say that the letters were overly prejudicial given the other evidence from Ms. Markham and from the guilty.
Well, that goes into the
Right.
next part of the argument, that those other rebuttal witness evidence, Your Honor, were very highly prejudicial, and that's one of the points, or the two last points, I think the key points, if you will, of the appellate argument here, is that those were over. But what I'm saying as far as that was concerned is if the court were to obviously agree with the appellant's position that those shouldn't have been in either, then also looking from the standpoint of telling the jury that this gentleman was in prison would be prejudicial. It's not like the cases. There are a couple of cases cited, I think it was the Ryan case and the Jackson case, which was cited by the Commonwealth in their brief, as to the inextricable intertwining, basically to clarify something. One of them was a woman was on work release or something like that, and they had to kind of explain the case. But in this particular case, it just seemed that this was an opportunity to get before the jury that this person had been, Mr. Facella had been incarcerated.
Now, what do we do with the interferon defense, where it was appropriately raised, but there's a statement from the defendant saying, I've got this defense in my back pocket, essentially, if you credit that testimony, right?
Your Honor, I don't know if it's credited or not. I don't know that. It's obviously very damaging.
Sure.
But I guess the fact that my point to the court would be, even if it's damaging, it's still true.
No, you've got two experts.
Yeah, I mean, him coming out and saying, "Oh, I've done my research and I'm on interferon, I can get away with it."
You've got two experts, and you've got family members essentially saying that once he started this course of medication, he changed.
Yes.
He was out of control. He was more aggressive, and the government's allowed to put in evidence of his conduct before he went on the medication.
Right. My point was, and we have a bit of a disagreement, respectful disagreement with the Commonwealth, is that the testimony that was given in the case in chief by Ms. Capaldo, which was 5 years prior to this, okay, also showed that he was not on interferon at the time. There was a question
right.
whether he was or excuse me, he wasn't by the medical records. I believe the medical records show that in 1995 he was on interferon.
What is your best date about when he started the course of treatment?
The treatment that was at the time.
No, when did he start taking interferon? What's your best?
My best is that sometime in 1995 he took something. I'm not sure. I'm not sure if it was interferon or was some other drug that would cause some type of a similar reaction, psychotic reaction. But my point towards the Capaldo testimony is that incident with the lady jumping off the balcony happened in November of 1997. And at the time, I do not believe that there is any evidence that at that time, which is late 1997, there was any interferon at that point in time. And that's the point where I was trying to get, that you already got a situation where in the case in chief, through admittedly testimony as to this particular this particular victim, there was.
So there was no need in your position.
No need to bring it in. Not that I totally agree with the case law that says just because it's not necessary doesn't mean you can't bring it in. Of course, but the whole point is I'm trying to argue that looking at the balance of the prejudice versus the probativeness of it, you've already got something that gives you that piece of information. So there's no need to bring in, and the rebuttal testimony was extremely prejudicial. Might be true, might not be true, but obviously it hurt the case tremendously. It was horrific, the testimony. But
remind me, did the counsel object to that?
Yes, Your Honor. All the 3 points that I had, the letters, the Ms. Markham and the who we're calling Beth, the other letter, the 12-year prior ex-girlfriend, all were objected to, Your Honor, yes.
Can I ask you, you make the point of the prosecutor's closing argument where the prosecutor basically says, it's propensity, this is who he is. It's pure propensity. There was no objection to the closing argument, and the closing argument is part of your prejudice analysis, but there's no separate claim for improper closing argument. How do we weigh that when there was no
I mean,
objection?
that really, Your Honor, kind of, obviously there's no objection. The standard is much heightened to prove in there. But there is case law that I did cite in the brief. I want to say Mills, but as I'm standing in front of you today, I wouldn't bet money on that one. But the fact that there are situations in which, even though the closing argument was not objected to, the fact that there was that such an argument was brought up in this particular case, propensity. Of course, the prosecutor could bring things along that line. It just the point is that I would suggest to the court that things went over the line. Things were. I think one of the cases that I talked about, the one that was overturned, was laced with all the prejudicial information. It seemed as though the prosecutor really harped on a lot of the testimony that came in from Ms. Markham and Beth, and that kind of goes to the overall general theme of the argument that bringing in the rebuttal testimony was brought in such a way as it did overwhelm the case. It was, I think there was one case, I believe it was Dwyer, that they made a big deal of the fact that witnesses had come in and they gave over 23 pages of testimony regarding uncharged prior acts against someone else. In this case, we have 17 pages. I mean, we're not counting, not counting on the fact that we're close in time, but the point being is that there was a lot of information disseminated as to these prior uncharged, or at least in one of the cases, the 23-year-old case, Ms. Markham was an uncharged bad act, very bad act, that seemed to be harped on in the closing argument. That went over the top.
In the opening statement, did the defense counsel admit that the defendant had done the killing?
Yes. There's no question that the defendant...
This is not a case in which propensity says, this is not a whodunit.
No, this is not identity. It's not one of those type cases. There's no question. There was never a case where there was looking at a not guilty.
Okay, so how does that affect the balance between probativeness and prejudice, where certainly the jury's not going to take that to say, well, this is the kind of person who would kill a woman and therefore I'm going to find him guilty. They already know that he killed her. The only issue is whether or not, what was the intent that he had in doing it.
Right. And there's also, Your Honor, I'll fully admit to the court, there's also, I mean, he had done this before. I mean, it was pretty, I wouldn't stand it for the court and insult anybody's intelligence by telling them otherwise. But the point being is that, you know, this is not a situation in which we're telling it, oh, this was Mr. Nice Guy and he just went completely off the wall. He had a horrific history. But the court, and I believe the trial judge used the word that was aberrational. And I think that was a little extreme. I don't think that was the argument as the trial counsel argued before, and when they were talking about, I think on day 7 of the trial, he was explaining the theory to the judge, and then of course during his closing argument on day 8, he basically said, we're not arguing that interferon made him kill. Okay, we're arguing that it took an already abusive, violent, depressed man who was subject to alcohol abuse and drug abuse. I mean, he was the perfect storm for not giving this drug to. But it took him, and he couldn't control. That was the exacerbating factor that it took.
Can I ask you about the purpose of the evidence? Because there's some discrepancy as to whether or not it was purely for propensity or not. And the prosecutor, as we discussed, argued pure propensity. That's who he is. The judge, though, in his limited instructions, after the guilty plea evidence and the live testimony, told the jury it was admissible to rebut claims of lack of malice, essentially. What's your thoughts, or what do you say about the limited instruction given by the judge? Was that adequate?
I believe, again, I still am of the.
I know there's an overwhelming prejudice.
Right, no,
but
I understand,
I want
Your
to get you
Honor.
focused
No,
on the instruction. What do you think about the instruction?
It's still our position that the instruction could have gone further.
In what way?
Well, perhaps that's the best instruction that could have been given, Your Honor, under the circumstances that all that evidence got in.
Yeah, and you're
I
not
would have
waiving.
to say that way.
I'm not asking you to waive your argument that
Right.
it's overwhelmingly prejudicial, but as far as the legal purpose in the instruction, it doesn't seem like there was error in the instruction.
Right. I just would argue to this court, Your Honor, that that could have been the best argument that could have been, but I think that the damage from all of that testimony from the two prior was so prejudicial that I don't know if this was anything that any limiting instruction could have done to pull that out.
But the issue is not whether it was prejudicial, whether it was unfairly prejudicial.
Well, yeah, Your Honor, that's actually right. I'm
But
sorry.
mean,
I
but-
should, of course,
no,
it's
but I mean,
prejudicial.
but I
You're
say
right.
it not to criticize
No, no.
you, but I mean, the gist of it is, you're saying that somehow the interferon pushed him over the edge, and these incidents say essentially he was already over the edge before he began to take interferon. Why is that? I know it's prejudicial. The stuff that was going on is
Sure.
horrific, but why is it unfairly so?
Well, it's my understanding from the case law, Your Honor, that even when you have these prior bad acts or other bad acts, as Creighton calls it, that there still has to be a safeguard by the trial judge as to balancing the unfair prejudice and also limiting in some way, either, as Dwyer suggests, a summary version of this thing. But I believe that the level of the detail that was brought in both of them, in the Markham testimony and in the from this the pseudonym Beth testimony, was just extremely unfair. I mean, talk about the situation where, you know, you're now forcing a defendant to defend against something that he wasn't charged with here. I mean, this was truly, Your Honor, I believe, a situation in which it was, you know, you didn't need to go that far. I mean, now, I suggest you didn't need to go that far at all because you had the Capaldo. But even if you went so far as to say, look, we have others that came in, the Commonwealth suggests we really couldn't do that on a summary type fashion. We have to show how badly it is. But it almost looks like, you know, and I can't speak for the prosecutor, but it almost looks like, boy, we were hoping you were going to say that because now we can let the floodgates open and we can really tee off. And I can't imagine any juror on the planet who wasn't extremely offended by that. And I just think that, coupled with the fact that the prosecutor on closing really harps on that, it kind of took it away from what's the argument that's going on as far as this particular killing.
Can I ask you, was there any objection raised to the age of these other bad acts, like 12 and 23 years?
Yes, Your
before?
Honor.
As to whether or not
as to
that
one
affected-
was that was one of the issues. It was too remote. It was the Markham case was 23 years prior, and although there is the case law that you can bring in evidence against other people. I mean, nothing's been given that long of a period of time, and the courts have talked about, and you know, if there is an overlap or a continuing.
But isn't the timeline defined by when the interferon starts? That's what's really relevant, isn't it?
Well, I was just getting into the
Yeah, I know.
timeline of that.
Right, because we have 12 years, we have 23 years.
Right, I mean,
but-
that
but-
was never-
but-
yeah.
But I think we need to look to see if it's going to be relevant, if his pre-interferon evidence is relevant, it has to be before he took the interferon. So-
Right, and as I suggested, Your Honor, the fact that the incident in 1997 was, well, he might have taken interferon before that, but I suggest that it was done and over with. And what we hear from the experts is it may linger in in a person for months, but clearly we're talking November, we're talking probably closer to 3 years after he took the interferon. And my suggestion. See, I've got just a few seconds left. Unless the court has any other questions, I'll rest on the brief.
Okay, thank you.
Thank you, Your Honors.
Ms. Semel?
Good morning. May it please the court. Catherine Semmel for the Commonwealth. First, in answer to Justice Gaziano's question, the date when he started taking interferon is not really precisely set in the record, but is testified to by his family members. And I have one citation, but I think there were multiple at transcript 7, pages 44 to 45. They said basically that he started being treated in the fall of 2001. I thought there was a reference specifically to November of 2001, but that may have just been in counsel's question.
So
But it was fall.
did the bad act evidence that came in during the case in chief include pre-interferon treatment?
Did the this interferon treatment? Yes, it did. But there was, as I pointed out in our brief, there was testimony in medical records that the defendant introduced a reference to the fact that he took a course of interferon treatment in 1995, and the acts that were testified to in the Commonwealth case in chief all were after 1995.
Counsel, do you know, is there any difference in how we look at time frame on prior act evidence depending on what it's being used for?
Absolutely.
Can you talk to me about that a little bit?
Justice Seifert, often prior bad acts evidence is used to show a pattern of conduct, a modus operandi, to infer from acting X way that he also acted the same way at a later case, and it's used that way by the Commonwealth in its case in chief. In that instance, there's a lot of inquiry and focus on remoteness because it tends to impact the probative value of the evidence. I think as Justice Gaziano was alluding to, when it's used in this case, the only important time frame is that it was before the interferon. And I guess I would analogize to a case of, let's say there's a charge of recent fabrication. There's some intervening event and a witness tells a certain story. If the witness told a story before that intervening event, whether it's 5 minutes before or 5 years before, that counteracts any claim that they were affected by the intervening event. And in this case, anything before the interferon was relevant, and that's what Judge Lowy found.
So anything, anytime before?
Well, I think that defense counsel.
I'm really just very confused. So you said, I'm really just trying to get the dates here. You said in 1995 that he did a course of interferon. He did it again in 2001.
Correct.
And that the ex-girlfriends, this 12-year and 23-year-old stuff was measured as of the time of trial, 12 and 23. But when did they?
No, the time of the crime.
Well, maybe another way of putting it is like, when did the girlfriends? When were these girlfriends in his life that he did these things to?
They were. The first one was 1979 to 1983, and the second one was 1989. This offense occurred in 2002. So the dates that are alluded to, the time spans were before the murder of Annette Soares.
Right, but also before the first course of
Correct.
interferon.
Correct. So before he had any interferon, as far as we know, he committed these acts.
Okay.
And that is exactly the relevance.
Was the closing argument proper?
Was yes. I mean, in this circumstance, it was. I think that
Isn't it pure propensity?
it's. I have trouble articulating this. It's a tough issue, but it's not. I mean, I think there are different kinds of propensity. There is the clearly inappropriate kind of propensity evidence, which is he's a bad person, he's done bad things, he must have done this bad thing. But in this case, it's not so much propensity, it's more counteracting a specific claim.
But the argument was that he essentially beats women. That's who he is.
Well, I think the deduction was that the interferon did not was not a factor in his killing Annette Soares because he had done similarly atrocious, violent things before taking interferon. So
But
it's
Counsel, don't we have, it just seems to me that we've got a perfect storm of prejudice here that's really, really very hard to see how a jury gets past that. You know, you've got this very old evidence. I mean, I understand the Commonwealth has a right to put on a rebuttal, but 23 years in the past, and the defendant has objected to this. And that makes our job a little easier in deciding what to do about it. And you've got the prosecutor basically saying this guy beats women, and that's why we told you all of that. I mean, how do we expect the jury to get past that in this case?
A couple of things. I would just, this is not directly relevant to your question, but I would just note that relevance was not objected to, that this evidence was not objected to on grounds of relevance at trial. Other objections were brought. That's not your question, I realize.
You're saying that the 23-year-old rebuttal evidence wasn't objected to?
It was objected to. It was objected to. It was not objected to on all the bases that are argued now on appeal.
Objected to on
a side issue.
remoteness grounds?
Yes.
It was,
Yes,
that
it
was one of the grounds.
It was.
So,
And
so
just-
if it's
and
so
Judge-
remote, doesn't that kind of cover relevance? If it's so old that it doesn't tend to prove what it's being offered to prove?
Well, I think the defense argument on appeal is that it didn't tend to rebut the defense at trial, and I think that is clearly wrong. As to remoteness, the Judge Lowy's answer to remoteness was that it didn't matter given the specific purpose of the evidence in this case, which was to show that there was pre-interferon aggression and hostility, which countered the defendant's argument that it was because of the interferon that he did this.
Why were there 2 incidents put in? Why didn't the prosecutor stop at 1?
That wasn't specifically discussed, I don't think.
I know it probably wasn't discussed, but why wouldn't the prosecutor in prudence say, I have the ability to prove pre-interferon assaults. I've got these 2 incidences. You know what? I'm going to put 1 in lessen the prejudice.
You know, that's certainly the prosecutor could have done that, and she's a smart prosecutor, and she might well have done it in another case, and I'm not sure why it wasn't done here. I would say that, you know, the fact that there were 2 different people involved just tends to buffer the point.
There was no cross-examination of the rebuttal witnesses.
Correct. Well, I know there was no cross-examination of the
Well,
one who testified.
there couldn't have been one.
The other one was a statement that was read into the record, primarily. Certainly the prosecutor could have. I would just say that it wasn't argued by the defense that why don't you stop at 1? It wasn't argued by the defense to take out little elements of the evidence. And Judge Lowy, I don't think it's news to this panel that Judge Lowy is a very thorough and meticulous reviewer of evidence. And in this case, he was very careful. He understood the issue perfectly. He understood that the issue was that this was clearly inflammatory evidence and that it was his duty to weigh the probative value versus the prejudice. He ordered a voir dire of Ellen Markham, the first witness, to ensure that he knew exactly what she was going to testify to. He went through the written statement and redacted things that he thought were not particularly relevant sua sponte, took out things about prostitution and sexual assault and everything to winnow it down to what he thought was directly relevant. Definitely, could there have been just 1 witness or 1 victim? Yes, there could have been. But certainly the fact that there were 2 over long periods of time is a little more weighty.
Could I get you to go back to my question about the confluence of all of this stuff, he beats women,
Yes,
and how that could have affected the jury's verdict in this case?
I think that in this case, you know, it comes down to jurors are presumed to follow instructions. And I know it's hard sometimes because, we certainly see things. We have cases where we say, there's no way the jurors could have followed the instructions in this case, but they're rare. I had one of them recently, but they're rare. And in this case, Judge Aloi's instructions were so clear as to not only here's what you can consider it for, but here's specifically what we're admitting it for. This is specifically what you can consider it for, and he did that during the direct case-in-chief witnesses, during Ribbento's testimony and Capaldo's testimony and the letters, and he did it again in different and appropriate terms during the rebuttal testimony. He also made a specific instruction following the closing argument with regard that was clearly in response to the prosecutor's closing, and I don't think indicated that he thought it was wrong what she had said, but that it could be misused. And I won't read it for you, but it's in our brief, and it's at page 72 of transcript 8, and he made very clear this is not a case. Oh, see, now I'm reading it to you, and I said I wasn't going to, but I will leave it to you to read. But he very clearly addressed it, and then he did it again in his final charge. And I don't think you could any more clearly advise jurors about permissible and impermissible uses of testimony than he did in this case. And we do rely on the fact, that's the only reason we can have jury trials is because we rely on the fact that jurors in most cases are presumed to follow the instructions they are given, particularly when they're very good ones and very clear ones. And I think that was the case here.
Do we have any cases with prior bad acts of this old?
I don't think I saw any. I'm trying to think. I think in Sharp, they might have been 7 years old. I don't think I saw any that were older. I also don't think that most of the cases about prior bad acts, most of them are not admitted for purposes similar to in this case. Most of them, I'm sorry?
They're not usually admitted as to propensity?
I'm sorry?
Not usually admitted as to propensity?
Well, they're usually, I'm sorry, that was imprecise. They're usually admitted to show pattern of conduct. And in that case, how old they are is important. And I think Judge Lurie was correct in this case that how old they were was not an element in this case. And I will say that defense counsel did, I think being a little funny, ask him, well, what if he beat somebody up in elementary school? And Judge Lurie said that would not come in. So clearly there are some limits. But in this case, when you have violence against prior girlfriends as an adult, then I think they were relevant.
So let's assume we do what you want. And what do we say when the next prosecutor comes and says the SJC has opened the door to the allowance of extraordinarily old prior bad acts?
I think that
which we probably don't want to do in general.
Well, I don't think you're opening the door to anything. I think that it is, I don't think there's any door closed to in the circumstances of this case, old evidence coming in. And that it is specifically limited to the facts of this case. It doesn't mean that pattern and modus operandi evidence from 19 years ago is suddenly relevant or admissible. Not, of course it's relevant, but it's not admissible. But in this case, it just wasn't a factor. Remoteness did not affect the probative value or the relevance of this testimony. That would be the difference.
Now, does it come in for propensity, or does it come in to rebut the claim that he did not have the intent to kill or to commit grievous bodily harm?
It's, this is a question that I've wrestled with about how to frame this. It is the latter. It comes in to rebut the defense argument specifically that there was something caused by the interference that caused him to kill the victim.
The closing argument gives you some pause, right?
It's, if you just read the closing argument and did not understand the issues of this case.
Like a juror.
But in this case, I think it's clear what the issues were. And as I said, Judge Lurie was very careful at the end. It's clear that the defendant was saying there was something, in closing argument, There's something different about what happened here relative to the others, and the difference is interferon. And the prosecutor was directly responding to that. And when you read her entire argument, I think it's clear that she's directly responding to
He
that.
starts out saying, there's a question about who he is as a person who beats women.
I'm sorry, I don't.
I'm paraphrasing, but he says something to the extent that there's a question, I'll tell you exactly who this person is. He's a person who beats women.
I'm sorry, I wish I had the exact quote, because I don't think that's a complete paraphrase of what she said.
Why was the defendant angry? Because that's who he is.
That's who he is,
It's
right.
the first thing she said.
That's true, but not, that's who he is. He's a person who beats, it's the last part that I was having trouble with. I think that's who he is in the context of this case, means that his history has been the same throughout, and that the defendant's argument that there was something different here, is invalid. And when it's viewed in the context of this case, in the context of the arguments, in the context of the defense closing argument, and the very clear instructions that were given, I don't think that jurors could have misunderstood that oh, he's a bad person, he must have done this. The point is that the defendant's argument that there was something different here is invalid. And to answer your question, Chief Justice Gantz, it does in a way go to propensity, but because that's the whole point of it. He did it then, therefore that's some evidence against his argument. But it's not
propensity is generally, the problem with propensity is generally when there's a question of whether he did it.
Correct.
But it's not generally relevant where there's no doubt that he did it. The only issue is, did he have the intent sufficient for a finding of malice?
That's correct. I do think there's a way that you could look at this and say that this is, I think Judge Lowy said at this point, well, he has in essence put his propensity at issue because he's made relevant his prior acts in this case to rebut his claim that there was something different here.
Well, didn't he put his mental state at issue, not his propensity?
His mental state
out of
was
control.
all tied into his actions. It was tied in by his family members who testified how he acted differently. It was tied in by the opening and closing arguments, which were that there is something different here, and the difference is the interferon, and it affected his ability to control himself, and it affected the fact that he killed Annette Swartz in this case. I'd be happy to answer any questions about the letter.
Oh yeah, why was I don't understand why it was plain or needed to be plain that the letter came from prison.
I don't think it was even explicit in the letter, and it wasn't like it was told to the jury, but when you read the letter, you would get the sense, you would probably deduce that he was in fact in jail or in prison. And I think the relevance of that, or the reason why you couldn't take it out, is because this was part of what was fueling his anger against the victim. And I think it foreshadowed the fact that right before he killed her, Michelle Rippentoe heard him yelling, "You got me in trouble with the police." And same thing happened when he was imprisoned before. He was angry at her, he was blaming her, and it was certainly relevant to his hostility against her and the cycle of violence in their relationship.
Was it elsewhere in evidence that the 1997 episode resulted in his imprisonment?
It was, well, first, I'm not sure it was clear that it was a 1997 incident, although you could certainly deduce it. But certainly the father had testified in this case, the victim's father, and had made reference to the fact that the defendant was in jail. And it's referenced in our brief, but it's at pages 196 to 199 of transcript 2. And I will say that the point at which it came in was confusing to me. But as to whether or not that the judge had ruled that it was proper, but it is referenced later in an argument at pages 157 to 158 of transcript 4, where the prosecutor in arguing another issue, noted that the father had already testified that the defendant was in jail. So whatever confusion there might be originally, I think it's clear on the record that that testimony did come in. So it was before the jury. And of course, as the court noted, the defendant declined an instruction on that point.
Okay, thank you.
We would ask the court not to exercise its discretion under 33E in this case. Thank you very much.